Just one rescheduled oral argument case remaining on our calendar for this morning. It's Portofino Tower versus Jones. Counsel for the appellant, ready to proceed?
Ready to proceed, Your Honor.
Please come forward.
Madam Clerk, I'd like to reserve 6 minutes for rebuttal. May it please the Court, Mr. Finley, Mr. Messer, my name is Ed Fleming, and along with Lou Rosenblum and Todd Harris, I had the privilege of representing the appellants. There's two issues that I'd like to address right from the inception. Number one is that we believe this Court correctly decided Ward v. Brown. We also believe you correctly decided the Burklow v. Brown, as well as the Bell v. Bryant cases. Number two is that this case is not Ward v. Brown. Ward v. Brown was based on the facts that were before that court, with the key operative fact being the document of conveyance that was before that court, i.e. the document that purported to be a lease. In Ward v. Brown, you correctly found that the estate in property, and that's what we're looking at here, is the estate in property was not a true leasehold as it never ended. As we will discuss, one of the key essential factors of a true leasehold is it comes to an end, and when it does, the tenant has no rights and the landlord has all the rights. That is called the reversionary right of the owner. When the owner rents, the other rights and benefits and burdens of an owner during the term of the lease. The other two cases, Burklow v. Brown and Bell v. Bryant, you found that the property appraiser improperly classified leasehold estates as real versus personal property, and that improper classification could not stand judicial scrutiny and was reversed. In all three of the cases, the courts focused on the document that conveyed the subject estate. Documents that claim to be leases, you looked at them and said, are they true leases? Do they create leasehold estates? If they do create a leasehold estate, that is a leasehold estate that qualifies under common law as a leasehold estate, qualifies under the statutory requisites as a leasehold estate, then it's very clear what the legislative mandate is.
Well, if this was one more year, if this was 100 years versus 99, would this be taxable then?
Yes, it would.
Written exactly as it is now, just one more year in term, it would be taxable.
That is correct. That is the bright line that was discussed in Ward v. Brown as a disqualifier.
So in that case, then it wouldn't matter what the language of the lease was, that it's going to be renegotiated potentially at the end of the lease.
Well, it would matter what the language was, in that if the language of the lease said it was for 100 years, even though it could be a common law lease, Judge Hawks, it would not be a lease that would qualify for treatment as intangible personal property under the legislative mandate.
So the only reason this is not taxable in your position is because the parties renegotiate at the end of the 99 years?
Well, that's not the only reason, but that particular factor that puts a finite termination date with no right to purchase, which separates it from the Hialeah case, for instance, and Bancroft case.
But in Ward, they had no right to purchase, but the only thing in Ward was that it was renewable at the option of the leasee, right? Actually,
it wasn't just renewable at the option, it was automatic and perpetual. That's what the Ward court found. It wasn't something that the tenant said, oh, by the way, I exercised my option. It automatically renewed in perpetuity, which means that the reversionary interest that the owner would be the hallmark of keeping fee title was gone. That was the key in Ward. Ward mentioned perpetual title on 9 different occasions. It mentioned end of lease, which is the equivalent of perpetual title, on 1 occasion, when it makes the statement that we find that the taxpayers are the equitable owners of the property. It cites to 5 cases, all of them having to do with leases in perpetuity, and every one of those cases says a lease in perpetuity is tantamount to conveyance of fee simple title.
Well, you know, there was obviously a lot of emphasis in that opinion on this perpetual renewal business. I know that was a very important consideration, but also the opinion makes reference to this concept of equitable ownership. And in addition to the decisions you were referring to earlier, it also cites the Parker versus Hertz Corporation. And I haven't read that in a week or so, but that was either a 25-year lease or a 50-year lease that was found to be taxable.
Certainly.
Now, this idea of equitable ownership, as best I can understand it from reading a number of the decisions, really is sort of a totality of the circumstances question. It doesn't strictly focus in on the term of a lease, does it? I mean, that's certainly an important consideration, but that's just one consideration in the range of things that should be considered in making this determination.
Absolutely, Your Honor, because the courts can look behind the form of the document to look to the substance. So, for example, you have a lease that says it's a lease. At the end of the lease, you're able to buy, as was the taxpayer in one of the cases that's before the court, it may have been the Hialeah case, I forget exactly, but was able to buy the property for a nominal sum, $1 at the end. The court looks at that and says, even though it's termed a lease, it's not really a lease. What it really is a mortgage parading as a lease. And so using the well-accepted equitable doctrine of substance over form, you say, even though it purports to be a lease, and even though you purport to be a tenant, you're really a purchaser. And the owner in that particular case holds title as security for your purchase, the same as a mortgage. So the doctrine of substance over form comes into play, and you can look at the substance. But how do you look at the substance of the transaction? You have to look at the substance of the transaction through examining the lease. In every case...
Well, you look beyond just the substance of the transaction. I mean, you also look at the continuing relationship between the owner of the fee or the remainder, however you look at it, and these tenants. And I think some control has something to do with it, too, whether or not they're in the interim exercising control over this occupancy and what can be done with the building, how the building has to be, and that sort of thing. Isn't that true?
Well, that's all determined by the document of conveyance. I mean, in every case that is relied upon by the property appraiser in this case, the document of conveyance...
That's not really anything, though, that the county maintained or this authority maintained any control over, is it? I mean, they didn't. There's nothing in there that tells them exactly how big the building has to be or where walls have to be or what color they have to be or anything like that, is it? Actually,
Your Honor, everything that was built on the government-owned property had to be prior approved by the government. The lease is called a development lease. The lease contemplates the development of condominiums. It contemplates an increasing rent price based on the condominiums. It even goes so far as to say that we, as the owner, can prescribe how you landscape this property and what type of amenities you have on this property. It is in every respect, and this is the undisputed record of the trial court, the affidavit of John Griffith, a real estate expert. It is in every material respect the same as other commercial or residential long-term leases in which the landlord, as part of the consideration, requires the tenant to build improvements that immediately belong to the landlord. And then at the end of the lease, all of those improvements continue to belong to the landlord. In our particular case, the title to, as soon as that first piling went in, title to that piling vested forthwith in the government. It always belonged to the government, always will belong to the government. Your Honor, I think that the case that really...
But the government can't come in there and occupy it.
Well, the government has rented the right of occupancy to the tenants, and that's the hallmark of a leasehold estate. You know, the Florida Supreme Court in the Rogers v. Martin case, which was cited in State v. White, we put the key blow up there, talked about the essence of what a leasehold estate is. And they held, during the life of a lease, the lessee holds an outstanding leasehold interest in the premises, which for all practical purposes is equivalent to absolute ownership. The estate of the lessor during such time is limited to his reversionary interests, which ripens into perfect title at the expiration of the lease. That is the hallmark of a leasehold estate. If you say that if the lessee during the term of the lease has rights like those of an owner, he's not a lessee, then you render the legislative enactments of taxation a nullity. You've effectively repealed the legislative enactment because it's very clear that the legislature intended to tax a leasehold interest as intangible personal property and nothing else. That's what the statutes say. This case, the State Road Department versus White case, was on the books at the time of the legislative enactment. This court has said in the Barnett case, for example, that the legislature is deemed to be on notice of judicial cases at the time they enact the statute. And so they knew that this was the definition of a leasehold estate, that definitionally a lessee, for all practical purposes, had a title that was equivalent to absolute ownership for the term of the lease. So if the term of the lease goes on forever, there is no reversionary right. That was the essence of the Ward decision. Yes, the Ward decision talked about benefits and burdens of ownership. But the first one that they discuss, and all 5 cases that they cite right after their ruling, were the perpetual nature of the lease. The other cases that were relied upon were cases in which, at the end of the so-called lease, the purported tenant could purchase the property for $1. In one case, $11 million minimum value property for $1. So what happens there is the owner gives up his reversionary right. And when he does, you don't have a landlord-tenant relationship anymore. You don't have a State Road Department versus White situation in which the landlord is renting his rights, which during the term of the lease are just like absolute ownership, but it comes to a finite end. So that's the distinction between our case and Ward versus Brown, Your Honor.
But in your case, the government, I would assume, has to negotiate with your clients in good faith to renew the lease at the expiration, correct? I mean, the government couldn't say, no, we're not going to, we don't want to lease it anymore.
Yes, they could, Your Honor.
I mean, because the lease seems to say that at your client's option, they can renew the lease for a like term, and then the next sentence, I think it says that the terms will be negotiated between the parties. So I'm not sure if their agreement says that the government could say, no, we're not interested in renewing the lease at all.
Well, yes, Your Honor, they could, because what it says is we will negotiate a new lease on such terms and conditions to be agreed upon. And that was the identical situation that was faced by the courts in Edgewater versus Holler and LaFountain versus Kelly. LaFountain versus Kelly, of course, is the first DCA case in which they looked at language that was virtually identical and saying absent advance agreement as to the amount of rent or definite procedure to be followed in establishing agreement to renew is too indefinite to be legally binding or enforceable. Your Honor, that clause, if you were to take that clause out of our lease, it gives us no less rights than we have anyway. A tenant always has the right to go to their landlord and say, can I negotiate a lease extension?
But that doesn't create an obligation on the government to negotiate in good faith?
It does. It does not, Your Honor. The cases that have looked at that, in fact, in Edgewater v. Holler, that was the argument that was being made by the tenant, is that there's this implicit duty to renew the lease on fair market value terms. And the court looked at that and said, we recognize that there's a split of authority on that issue in other jurisdictions. And some courts say, well, they meant something when they said they have an option to negotiate. And so to give it some force, we're going to say they have an option to negotiate on fair market terms. And then there's another line of cases that say, no, it's too indefinite to be enforced. We follow, in the state of Florida, the second line of cases. That's what Edgewater versus Holler said. LaFountain versus Kelly, first DCA, says the same thing. We follow that line of cases. It's a nullity, it's illusory, and it's unenforceable. So that's the state of the law in the state of Florida on that option to renew issue. And you didn't have it wasn't an option to renew in Ward versus Brown. It was perpetual automatic renewal.
Does this come down to that one sentence then? I mean, wouldn't this case be completely identical to Ward if it didn't have that the parties shall negotiate the terms and conditions?
No, Your Honor, because in Ward versus Brown, the lessee was not a lessee of the improvements for 2 reasons. Number one is that the lessee had title to the improvements during the term of the lease, which put him on the same position as the Parker versus Hertz case, Marathon Air case, in which the lessee had title to the improvements during the term of the lease. That's a disqualifying factor under paragraph 6 up there under the Florida statutes. Nothing shall be deemed to exempt personal property, buildings, or other real property improvements owned by the lessee from ad valorem taxes. And the court said that ownership is during the term of the lease. So Ward versus Brown, when did the government own the improvements? At the end of the lease. When was the end of the lease? The court said never. It's perpetual. In our particular case, the language in our document says that title to the improvements vest forthwith in Escambia County, and that's where it stays. So that's a critical distinction between our case Ward versus Brown had a statutory disqualifier. Ward versus Brown also, you have to go back and say, is it a leasehold at all under the definitions of common law, the definitions of State Road Department versus White, quoting the well-established case of Rogers v. Martin, is that a lessee during the term of the lease has an estate that for all practical purposes is equivalent to absolute ownership, but that ends. And when it ends, what does the tenant have? Nothing. What does the landlord have? Everything. So those are both key distinguishing factors between our case and Ward versus Brown.
You're familiar with the lease that was involved in Alvin Stores. I know that was a PCA, but I mean, you're familiar with the lease there. Is there a material distinction between the lease there and the one involved in this case?
Your Honor, what I know about Alvin Island case, and I was not involved as a lawyer in that case, is that there were multiple leases involved. And what those multiple leases said, I don't know. How you join multiple leases in the same case, it would seem to me to be an improper joinder, because the document of conveyance is the document you look at for establishing the leasehold estate and determining whether it is a true leasehold estate or whether it's a sham or a pretense, whether it's a mortgage parading as a lease like the Hialeah case, or whether it is a lease that qualifies on every respect, both common law as well as statutorily as a lease.
Okay. We'll reserve the balance of your time.
Thank you.
May it please the Court, my name is Tom Finley. I, along with my co-counsel Elliot Messer, represent the property appraiser Chris Jones and the tax collector Janet Hawley. First of all, I can answer the question about Alvin Stores. There were leases that were as short as 30 years in that case, and there were many leases with no renewal options whatsoever. But I do understand that it's not binding and it was a PCA. Secondly, I'd like to dispel the notion that the subleases, that is to the individual tenants or unit owners in Ward v. Brown, was automatic. In fact, it was the lease between Escambia County. Let me back up a little bit. When the land was first deeded to Escambia County, there was no Santa Rosa County. When Santa Rosa County was created, Escambia County entered into a lease with Santa Rosa County saying, all right, here's your part of the island, 99-year lease with automatic renewals for 99 years. That's where the automatic language came from. If you look at the individual leases, one of which is attached in tab 10 of the appellant's appendix, you can see one of the Ward v. Brown leases. It's a lease between, I think the owner's name is John Michael Hughes and Nicole Hughes. And in the renewal provision, it says the lessee shall have the right and privilege at this election to renew this lease for the further term of 99 years by giving written notice of such election to renew not later than 6 months prior to the expiration of the term. So it's not automatic as they suggest, and I noted in their reply brief that they compared the Escambia County Santa Rosa language with the language in their own subleases, which I think is not apples to apples. Secondly, with respect to the court's raising of the question of Parker v. Hertz, that was a 25-year lease. And at the end of that lease, Hertz was required to convey all of its interest, including title, back to the governmental entity. But the court still found that there was equitable ownership. Broward County versus Eller is a case cited in the appellant's brief. That's a Broward County case where there was a 50-year lease, and the court said in Eller that the lease wasn't clear where title was to the improvements during the term of the lease, but the court said with that 50-year lease there's enough indicia of ownership for equitable ownership. So you have Parker, which is 25, Eller, which is 50, Robbins versus Wellbaum, a homestead exemption case, which is only 10 years. It was a property placed in trust. So there is no bright line 100-year test. Ward v. Brown said there was no bright line 100-year test. The 100-year statute says on its face exclusive of renewal options. So even in looking at Ward v. Brown leases, the first DCA, the court that handled that case said that 99 years exclusive of renewals, that doesn't qualify for the 100-year bright line test in 196-199-7. Ward v. Brown said that that statute didn't control. Parker versus Hearst expressly said that statute didn't control. Hialeah expressly said that statute didn't control. There is no court that has found that the 100-year provision in 196.199.7 is a bright line test
On
of
the
any sort.
downside, it would control on the upside, wouldn't it?
It would control on the upside, and that's exactly what Ward v. Brown said. So this test only applies if the lease is 100 years or more, but all of the courts have said this isn't going to control us in determining how to look at the extrinsic criteria which could establish ownership in the tenant of improvements.
How do you explain the provision that at the end of this lease, they negotiate for the terms and conditions for the renewal?
Well,
is that just language that was thrown in there and it means nothing, or does it mean something?
I think it has to mean something, and I think that even the LaFountain case that they've cited, and certainly the State Road case, say that there's a compensable interest in a renewal right, even when it hasn't been, or if it hasn't been negotiated and failed, then there's still a right to the renewal to the renewal option. It's only when negotiations have failed, and there's no record evidence of that in this case, that that right vanishes. In any event, I would say that we've got to get back to what's important in this case, and that is these are condominium units. And we've got a Portofino Condominium Association of unit owners coming in and claiming in their complaint that they want a declaratory judgment that they're not the owners of their condominium units. That's in the declaratory judgment count 1. They want a declaration that they, as the Portofino Condominium Unit Owners Association, their members don't own their condominiums. So condominiums is a little bit different than the average lease when you're talking about renewals. For example, there's an anti-escalation provision that it's void against public policy if you have a land lease to escalate the rent. And so I think there are some parameters here that would put an absolute duty, especially on a governmental entity, to negotiate in good faith at the termination of the 99 years. But what we have here is a condominium unit, and we can't forget that. And the legislature has determined that a condominium unit is, quote, a form of ownership of real property, end quote. So we're beyond, and if you look at the San Sushi case that this court authored, there was a dispute over whether the condominium unit was actually leased. It was a dispute over the escalation clause. The developer said, we can escalate the rent because we're not just talking about a land lease, we're talking about a condominium lease. The people in the condominiums, and this is on Pensacola Beach with the identical lease provisions, said, wait, this is a lease of land, because then the anti-escalation provision would apply. And the court said, yes, this is a land lease. In order for there to be a sublease, there has to be an underlying lease. And if you look at the underlying lease, it's for land only. Therefore, San Sushi Court, the First District Court of Appeals, said, quote, it is a lease for land. Clearly, the parties at bar could not have intended to have entered into a sublease of condominium units, end quote. They also said, quote, we are unable to understand how or why someone would purchase a unit from a developer and at the same time agree to lease the same unit from the developer until the year 2069, end quote. So what we have here is the court is looking beyond the formality of the documents. The court is looking to the principles of equitable ownership, which are underpinned by fundamental constitutional provisions that require an equitable distribution of the tax burden. There have been 4 cases out on Pensacola Beach where the Supreme Court has said that to allow a private leaseholder of governmental property to escape taxation would be unconstitutional. And I realize the holding of Zingali versus Crossings is here now in the Supreme Court, but what I'm asking the court to do is to construe these statutes in order to reach a constitutional result. And the only constitutional result that we can reach under Sebring, Williams versus Jones, Archer versus Marshall, Ampey versus Kennedy, on, Strawn versus Camp, is that these private leaseholders must pay their fair share of taxes. Now, I would note that Mr. Rosenblum conceded at the summary judgment argument, quote, it is true that the lease fees that my clients pay do not go into the general fund of Escambia County, end quote. There was an uncontested affidavit that we put forward that said they have tried in the past, I don't think they argued it so much today, but in the past they've tried to argue, well, the lease fees, they're the equivalent of taxes. The Supreme Court said in Archer versus Marshall, lease fees are not equivalent to taxes. Lease fees are for the use of the property. Taxes are for public services. And we put forward the affidavit of the Escambia County budget manager, who said that none of the lease fees go into the county general fund, and none of the lease fees go to the school board.
Well, your argument is almost like we don't care what the lease says, it's taxable.
Well, it's a condominium unit that's real property, and real property is taxable. It's got all the attributes that Ward v. Brown went through for equitable ownership,
So once they
and it has
file
those.
condominium documents, under your argument, once they file those condominium documents, that's it, it's taxable.
Well, I think you have to look at all the facts and circumstances, but I think that would be an argument that we would make.
Well, if the argument that condominiums are real property, you said this is a condominium, therefore you said it's taxable.
It's real
I
property.
mean, that's your argument. It doesn't really matter that the lease is negotiable or how
Doesn't
long
matter.
it is, or none of that really, once we have a condo.
That's correct. Now, they have argued a case which they filed as supplemental authority, which was a 2003 case. It wasn't important enough for them to cite in their main briefs, but it's the Nicholas case. But that's completely distinguishable because in that case, the association conceded that they were only interested in air rights. Sort of like the Berklow case, there was only a matter of water rights, not real property. And also in Nicholas, it dealt with an airport, and there's a separate statute that says that if you've got FAA approval in the context that those taxpayers had it to be on that airport, then that serves a public purpose. In this case, in contrast, we have several times the Supreme Court has concluded that there is no public purpose that's served out on the beach. Williams versus Jones said that these weren't public purpose, that the leaseholders out there weren't serving a public purpose. Strawn v. Camp said it. Ampey said it. It's been said over and over and over. I would submit that Ward v. Brown is not contingent on there being perpetual leases. One of the arguments, or one of the holdings made in Ward v. Brown was that there's a 98-year provision in the Florida Constitution, which would clearly cover these 99-year leases. And that's in Article 7, Section 6A. This court held, quote, moreover, the Florida Constitution expressly contemplates equitable ownership for leases with initial terms of 99 years by providing homestead exemptions for leaseholds in excess of 98 years. See Article 7, Section 6A, Florida Constitution. Accordingly, we agree with the trial court that the appellants are equitable owners and their property is not exempt from taxation, end quote. So that alone, the condominium status alone, this provision alone, many provisions alone would require that they be taxed as real property. But in addition, regular old equitable ownership argument using the benefits and burdens of ownership would also suggest that they are owned.
Well, when you were talking public purpose, you were talking about the exemption because government-owned property used for public purpose is exempt. Is that what you're talking? I mean, is that why you referenced that these were not public purpose?
I'm distinguishing the Nicholas case, first of all. But secondly, yes, there's constitutional doctrine which must be read into any statute.
But a county, they don't have to use their property for public purposes to be exempt, do they?
A county is an immune entity.
Right, so they don't. So this would be immune.
Well,
if it were owned, it wouldn't matter what they could put McDonald's out there.
Yet Strawn v. Camp dealt with these leases, and Strawn v. Camp said there's not a public purpose that the Constitution requires that a governmental leasehold, if used for private purposes by a private individual, must be subject to tax. There are many similarities between Ward v. Brown and this case. In the Ward v. Brown, I mentioned that there was the lease between Escambia County and Santa Rosa County. All this land stems from the same land grant. So when they argue that, well, the land grant from the federal government said you could never convey away bare legal title, that applied in Ward v. Brown, that applies in this case. If you compare the language of the lease that I brought to your attention in tab 10 of their appendix with the lease in this case, you'll see it's virtually identical. And you'll see that the same lease in the Sanssouci case is virtually identical. Finally, the trial court order at page 9, which is also submitted as part of their appendix at tab 8, said that the leases in Santa Rosa County, this is pursuant to the Escambia County, Santa Rosa County lease, the terms of that lease say that any lease in Santa Rosa County, which is the Ward v. Brown leases, must be, quote, substantially upon the same terms, considerations, conditions as like leases that in use in Escambia County. So we have the same thing. We have the same thing in Ward v. Brown as we have in this case. And I think that The court certainly, when the appellant's counsel in Ward v. Brown conceded that they were virtually perpetual, that was the easy way out. But I would submit that the Ward v. Brown was not contingent on any finding of interest in perpetuity, and I think that's clear from a number of things, including their citation to cases such as Service Metro, which was not a perpetual interest, no option to purchase. And I would note that Judge Polston wrote both Ward v. Brown and the Service Metro decision, and so he knew what the situation was. Ward also cited Archer versus Marshall. That deals with Pensacola Beach leases. They also cited to Parker versus Hertz in the Hialeah case, 25 and 30-year leases. They also included the 98-year provision as a bright line. Finally, they said that the statutes apply not just to leases in perpetuity, but also to, quote, any other circumstances from which equitable ownership can be found, end quote. So it's not contingent on perpetuity.
Judge Polston could have written his opinion from your argument. He could have said equitable ownership exists here for these reasons, but golly gee, I don't know why we would discuss all that, because they win because they filed the condominium documents. And holy cow, we don't even need to go that far. Once there's a lease for more than 98 years, they win.
In Ward v. Brown,
he wrote a lot he didn't need to write. I mean, right?
Yeah. In Ward v. Brown, there were some that were not condominiums. There were some single family in there. So I think that was not an all-encompassing theory for those. It was not a class action either. Are there any questions that the court has?
Well, one thing Judge Polston was dealing with was some existing precedent in this court. That's one reason he needed to deal with that distinction, isn't it? Don't you think?
I'm not sure I follow that.
Wasn't there a prior decision that had put extreme reliance on the lease being short of 100 years?
Well, Bell v. Bryan was out there, and so I think that's correct. Judge Polston was probably...
That might have been what was in his mind when he was writing this opinion the way he wrote it.
That could be, and you were a concurring judge on that, so maybe that is the case. I don't know. But I think that's right. I think that Bell v. Bryan was out there, and the court found in Ward v. Brown, Bell v. Bryan is not controlling because it didn't address equitable ownership. And I think that's a correct ruling. There's no analysis of equitable ownership in Bell v. Bryan. In addition, that was during a time period when this court relied on just legal title in order to determine ownership for tax purposes. If you look at the Leon County Educational Facilities Authorities case, in the first DCA, this court said, well, legal title is in this entity, so they own it for tax purposes. Went up to the Supreme Court, and the Supreme Court reversed and said, you can't just look at legal title, you got to look at equitable ownership. That didn't mention Bell v. Bryan, but I think that overruled the analysis that had been undertaken in Bell v. Bryan. So I think it was appropriate for Judge Polston to write the opinion that way.
All right. Thank you, sir.
Thank you.
May it please the court, there's three issues I'd like to address from his argument. Number one is they argue that if you look like an owner during the term of the lease, you can't be a leaseholder. But the essence of a leasehold estate is you look like an owner during the term of the lease. And that's what the courts say. The other is trying to import facts from one case over to another. If you change one line in the Hialeah versus Dade County case and take away their option to purchase for a nominal sum, you have a true lease. You don't have a mortgage parading as a lease. So the language, every word used in those leases is important because the rights that are given in the lease determine whether they have a leasehold estate at common law and statutorily, or they don't have a leasehold estate. Number two is in trying to argue that the leases did not have automatic renewal clauses. Ward versus Brown, of course, prints its facts on which it relies. And if the court misunderstood those, it misunderstood those, but those were the facts on which it put within its opinion on which it based its opinion. And what the opinion says was the land underlying appellate's improvements was conveyed by the United States of America to Escambia County in 1947. Escambia County later leased this land to Santa Rosa for 99 years with automatic renewals for additional 99-year periods in perpetuity. It is undisputed that appellants have the right to renew their own assigned interest in this land lease for the same term of Santa Rosa County's lease term from Escambia County, thereby providing appellants with the same right to perpetual renewals. That was the basis, the factual basis. The court then goes on to say, in talking about the bright line test, it says, just as Judge Hawks points out, it's an excluder. If you've got a lease of 100 years, you don't need to look any further. If you got a lease of less than 100 years, yes, you have to look further. You can have a lease of 5 years. It's not a true lease. If you have an option to purchase at the end, why? Because the owner's given up his right of reversion. What they say is that about that provision is that a plain reading of the section, and that's the section that is listed on your chart right here as being number 5, originally leased for 100 years or more, as a disqualifier. Plain reading of this section indicates that it does not address 99-year terms with automatic renewals for additional 99 years in perpetuity. They go on to say in paragraph and footnote 1, I'm sorry.
No, I'm sorry.
They go on to say in footnote 1, in talking about the issues, there is no end to the lease. I mean, so it's very clear that the Ward versus Brown court was depending on that factor. Now, if you had a situation in which you had a perpetual lease, but you had no other rights of ownership, for instance, you didn't have the right to possess, then you could have a situation in which even though the lease went on forever, you could have a common law leasehold estate. You couldn't have a statutory leasehold estate because you didn't meet the disqualifier of 100 years, but you could have a common law leasehold estate. And you can have situations, and there's numerous ones cited in the Hialeah case, the Bancroft case, the Barnett case, the First Union case. These are all cases of leases of less than 100 years that purport to be leases in form, but when you look at them, the substance is at the end of the lease term, the purported tenant can purchase the property for a nominal sum, and that's a conveyance with a financing situation in which the owner keeps their legal title.
Is that what was involved in Parker?
No, Your Honor. In Parker, they owned the leasehold estates during the term of the lease. They owned the improvements during the term of the lease, and that's factor number 6. That's a disqualifier statutorily. That was also true in Marathon Air. They owned the improvements during the term of the lease, and so it doesn't matter that they're a common law leasehold estate if they're disqualified by the statute, by the taxing statute. And so both in Parker v. Hertz, in fact, in Parker v. Hertz, the tenant there was arguing the opposite. The tenant admitted, well, I've got legal title, but the governmental entity has equitable title. And the court said, no, you've got legal title to this. And in addition to legal title, you've got right of possession. You've got the type of things that a leasehold estate would normally have, or an owner would normally have. But key and foremost, you have legal title, which means you're just leasing the land. You're not leasing the improvements.
So it was finite. Though it was finite.
That's correct, and it was a finite term. So, Judge, let me address the 718 argument very quickly. Is that, first of all, the Nicolaitis versus Runway case said that Section 718.106 provides that condominium parcels are separate parcels of real property. However, it does not address the question involved in this case, which is who owns the land and improvements. Well, that's exactly the situation we have here. Next, let's look at 718.
Well, I think we're probably going to need to wrap up. If you want to take about a minute and a half to wrap up, your time to expire.
Thank you, Your Honor.
Yeah.
The developer of the lease on 718 is the type of property that you can submit includes a leasehold estate. And the documents before the court show that what was submitted to the condo form of ownership was leasehold estates. And it particularly says in the declarations, ownership of each condominium unit shall be in sub-leasehold estates. So it's a leasehold estate that's submitted to the condo form of ownership, which is contemplated by the statute. In fact, there's a whole section of 718.401 that addresses leasehold estates, even addresses leasehold estates from governmental entities. Judge, in summary of our position, as found by this court in its recent decision of Berklow and its earlier decisions in Bell v. Bryan, chapters 196 and 199 mandate, it's not permissive, they mandate that leasehold estates be taxed as intangible personal property. These statutes do not allow the executive branch, in this particular case the property appraiser, to unilaterally decide that another taxation method is fair or produces more income for the public, or that they like it better. It's mandatory. So the question before the court is this a leasehold estate as defined by law, as defined by State Road Department versus White, Rogers v. Martin, and years of law? Is it a leasehold estate? Do any of the disqualifiers work against it? No.
I think we got you.
Thank you, Your Honor.
All right, thank you, Sheriff. Thank you all, and that is the only case on our calendar, so the court will now be in recess.